quite an eventful day at the Supreme Court of Ghana. And in Sembebrina na Akoso Supreme Court, Enche will be going live to the apex court of the land na afe. And the court na delivered two major rulings. And yebeko na yakwakwa kofa the course court and etumi the abremidiri say on social media move follow your coverage of the 2020 election petition and the Bremo live from the Supreme Court. Oko Asempa FM 94.7 yen page on Facebook Asempa 94.7 FM ubetimi follow the live coverage of the election petition and also on all other platforms here at the multimedia group. In the Enyumrei, and I say we are bringing you a review of the Ekosiisen Ewo Court. And Monshan so Emfa MIA. Yene lawyers mpenyifoni bebrena bedin komo would also go to the camp of the petitioners and have a first and second respondent na yahwe edin komo so Eddie free hoba first we'll get our court correspondent na ene the Ekosiisen court no wetimi di munsem nyina atoye nanim. But the news is that the Supreme Court of Ghana had dismissed the application for and I said the review on its ruling on interrogatories in the Obekaya the petitioner the questions I would obey do me 12 by say ankomo ba best court kwan na court ama won kwan say electoral commission enyi sa ensem dumienu no ano. Court no by unanimous decision 7-0 ebogui say nya de ombema petitioner metre John Dramani Mahama sa kwan no. Na lawyer for a file review inti emrane makwan say Supreme Court ema ruling bi na wani nhyeda enye ho a ubetimi akọ for review. Na say ye for review a ye the judge for ni bi eba beka judges a etna asem no so bra edi kan no eho into mo beka ya election petition case where a judge for chief justice epa won chief justice nankasa eka wo mo ye nson ena omurulu initially say omo makwan emma petitioner na mfa sa questions do me no emma electoral commission it na 7-0 decision na 7-0 decision of the court and it to me a course so it say mu follow ya the sansem ni nyina ebremo enti ena court no etna so no judges ni mienu beka ho ma na 9 but even before the review no NDC and say petitioner and lawyers file the friend supplementary application be to make sure say councils no able to make the supplementary your friend is saying and as a court be ma won kwan na omode other grounds for review no aba and it's our grounds na NAD kind Supreme Court na so omohwe ebo etugu ye ntina koye 9-0 and later almost sign so eba bio say yentina review case na nkasa so eno nso no ade a eno nso kokopie mu 9-0 enti sana ekokosi enche yebeko na afei yakọ akwa press conferences are Ekosiisen Ewo Supreme Court inti counsel for petitioners no and afe counsel for respondents no kasa enti yebehwe na yakọ akwa de abremo inti munsha nso emfa ema Ekosiisen so ni haya Asempa FM
Asempa FM. Asempa FM.
it said them can and che yebeko na ye court correspondent Eddie and Komo free Supreme Court ahwe enne nsemo a course so ba yaboafo e wodwumadi so sound of our time ye wo Agbeve Herbal Center mo de Mona soap and Mona cream abadwa so amponsa ifa pharmaceuticals e ka aboafo no ho mehia sem segment nso Ecobank Ghana 21st Century Clinic Awake Purified Drinking Water and a Rockstars Roofing Systems omunyina aboa ne de mehia sem segment nso e de bremo ye one-on-one interview session nso Bell Aqua Heaven Insecticide Spray and Coil and Napa Foods omonso eboa Franco Trading Enterprise Bell Aqua Active TCL The Creative Life Dependable Herbal and a Global Lighting Center Limited and so kan ho and your discussion segment no etumi ede ebremo entimonhya nso emfama yenko Supreme Court na fe press conferences are ekoso after the ruling yenko TV
on grounds of expedition is denied the right to serve interrogatories. That is a denial of a right to a fair hearing. And so we are saying that the refusal of our applications are not fair to the petitioner in the light of the past and in the light of what is happening now. So we disagree with the rulings of the Supreme Court. Unfortunately, that's their decision. There's not much we can do. We'll be in court tomorrow to start our case.
Okay, when they ask a question as to why can't we?
Well, of course, that's one of the reasons why we are saying that it's unfair to our clients. They have actually said, and you heard one of the questions that was put to the lead counsel, that if you can put those questions to the witness during cross-examination. Now, the decision has said that those interrogatories are not relevant. If they are not relevant now, how can they be relevant for the purpose of cross-examination? We anticipate a situation where we will be stopped from actually asking those questions. And of course, it undermines our case.
You sound as though there was some grand scheme to frustrate the case of the petitioner. Is that your...
I haven't spoken about any scheme.
Leave that to the public.
I'm talking about our experience in the... Of course.
And our disagreements.
You said yes. The court had not been fair to the petitioner. You also said that in 2012, 2013, in the case that the then petitioner Nanato brought,
Asempa
there were
FM.
no rules guiding the service of interrogatories. He was allowed...
Answer that question yourself.
I'm sorry?
Answer the question yourself. Was it fair? Is it fair? I will leave that to you to decide, and the Ghanaian public to decide. So you tell me, was it fair?
Any other question?
Any other question? We are not withdrawing our case. We will continue with the case. You will all see what will happen in the Supreme Court.
Court of public opinion. Are we? Okay. Thank you. Thank you very much.
Asempa FM.
I'm doing it.
Okay,
Take the drug. And Bamcho, Etiawamono, near Esi and Neno, Aya Araho, Asempa Nesi. And send me no any a dark court anymore and near Dick and say, on my own coin. Na yamfa another ground anka ye review na ye ka sanke peno court no call etu agina ba no on betugui ye tosi me no say review na nka say nemu ankata mu hu ensemo a ye lead counsel chachuchi kata ode to ho ensema kase ni quotations ne mra oprugu ho at the end of the day court say on ye enya adwen enti sansem mienu ni na court atragu na ne awreho mu ni se as otwitsere mienu sensene so yi ba ko nya ba ko 2013 Nana Kufuado Petition ya oye so baby sansem bi ye manu kwa mo bi sansem no den na aba na John Mahama de opese obisa court so man kwa no misa.
So we've just been listening there to Mr. Baba.
Asempa FM. Asempa FM.
Okay, inti lawyers for the petitioner and Motese na omo kasa inti Marietta Brew, former Attorney General of the Republic and Okasa edema petitioner no lawyers na the all Kenyan and so mufi se court no answer da ni won ni yi na they are disappointed in the ruling but they will still come back tomorrow and begin their case. Enti ye hwe se enomu nchemu na lawyer Baba Jamal ma ye hwe se respondent ne nso eba ba be kasa lawyer Frank Davis crowd no nso ye be kwa akofa na ya hwe ensemo a omo nso tudwa na afi ye babaka na inkomo ewo hu nyina na yetimi atoamo so Ekosiisen so ni high Asempa FM nti tell a friend to tell a friend to tune in to 94.7 and that Ghana's biggest and the most authoritative political, social, current affairs talk show is airborne. Here, papa, into Monshan and so. Your affiliate radio stations now across the length and breadth of Ghana. Yadamunya say, Adansia Radio, Ewo Asantia Chem Agogo. Yamamunyana Akwaba or Boasefo Sumuti Ewo PZ Radio Yamamunyana Akwaba Oko Sunyane a higher Storm FM Yamamunyana Akwaba Sanso and Atamale a higher ABC Radio Yadamunyana se Esaimamo Akwaba Bibiani for Mutie Yamama Akwaba higher Chiame FM Oko Sekendi Takrade Aseda FM and the other say Frank Davis Haykrado Yankwani Yankunkuti on so.
Their statement of case was roundly dismissed 9-0. Now the review application itself suffered a similar dismissal 9-0. So for my friends on the other side who are interested in the number of goals scored, is now 18 goals to none. 9 justices plus 9 is 18. So we are leading 18-0 for today.
Asempa FM.
Now I was listening to what my friends, petitioners legal team, were saying to you a while ago. You see, when we come to court, we are guided by procedure. It is not what you decide to do in court. It is the procedure of the court which governs proceedings in that court. My good friend Marietta Brew upon Apia, who was the Attorney General of the Republic. So is my other very good friend, Dr. Dominic Ayeni, who was the Deputy Attorney General. It was in their time as leaders of the bar when the CI 99 was drafted and passed into law. I think it's unfortunate for Marietta to stand before you and make those comments that she makes.
Asempa FM.
The law is not about what you want. It is about what you will get. And this business of they're talking about fair hearing and all that. In one of the authorities that their lead counsel, Mr. Tajikaka, quoted, it was stated quite clearly there that speedy hearing is synonymous to fair hearing. So I don't know what this fetish it is about. Expedition being sacrificed for justice. In the case that he himself, Tajikata, quoted, it was speedy hearing is fair hearing. And I don't really get the complaint When you come to court and your mind, with all due respect, is jaundiced, that you should expect a certain ruling from the court. That is what is occasioning when the ruling goes against you. In the courtroom, I heard my sister Marietta also saying that their lead counsel preferred superior arguments. Really? Superior arguments. Indeed, if the arguments were superior, 9 justices will not find that argument not superior. So that position they are canvassing is neither here nor there. In any event,
Ekosiisen on Asempa FM.
If you are emotional about a ruling, that is what you will get. And at the JSC, in one of the celebrated cases in our civil jurisprudence, had this to say in a case which came before the Supreme Court, in Mechanical Lloyd versus Natty, that a review application is not an emotional reaction to a ruling of the court or to an unfavorable judgment from the court. At all material times, you should lead exceptional circumstances and discovery of new matters which are not available to you at the time the ruling was being rendered. The same emotional sentiments in court is the same emotions which have been replayed here by Marietta. I'll urge my friends on the other side that since we are all contesting this election petition on CR 99, they should address their minds to the dictates of CR 99. And this business of His Excellency the President Nana Akufo-Addo being granted leave in the 2013 election petition to serve interrogatories on the EC. And this time round, the petitioner, Dramani Mahama, is being refused. You see, we should not reduce the practice in our cause to ad hominem applications. That because something happened the last time, it should happen this time round. The election petition of 2013 was not governed by CI 99. See, those are the differences. The mere fact that Nana Akufo-Addo, the President of the Republic, was granted interrogatories at that time does not necessarily mean that the interrogatories this time should be granted. The court was precise that it had to do with relevance and matters in controversy between the parties. So if issues are joined and there is no matter in controversy, you don't come for interrogatories. The interrogatories you are seeking for can be gotten in cross-examination. So I really don't see what my learned friends are quibbling about the rulings of the court this morning, through this afternoon. We are satisfied. Some of the 12 questions my learned friend Tatikata referred to, those 12 questions had exhaustively and extensively been answered in both the answers by first respondent and second respondent. So what is new? There's nothing new. This business of when the chairperson of the EC realized that, she had made a mistake or something of the sort, and who did she consult before she announced the new declaration or the new result she came out with? Please. How relevant, ask yourselves, how relevant is this to the issues that the court have set down for trial and determination? See, let's focus on what is going on in the Supreme Court. And let's play to the gallery. With all due respect.
Asempa FM. Asempa FM.
No, what the question was?
Ekosiisen on Asempa FM. Asempa FM.
Oh, for me, when you make allegations specific allegations against persons, you should be able to prove them. These bare and pedestrian allegations are not matters that engage our attention as lawyers. It wasn't part of their case from the get-go. So where is this business of blood relation between the chairperson and Rebecca Akufo-Addo, the first lady, coming up? I mean, when did they realize this? These are pedestrian allegations. I don't think we should pander to them. In any event, he will get into the box tomorrow. I hope he comes. He will get into the box tomorrow and we'll deal with it.
Any more questions?
Asempa FM. Asempa FM. Ekosiisen on Asempa FM.
Thank you, Moment. Your appreciation of what is emotional and mine is different. I am a trained lawyer, so when I'm listening to submissions, the cases he quoted, I must confess, were totally irrelevant to the issue before the court. He had the ruling of the court. He spent more time trying to convince himself, not the court, that those cases he quoted were applicable to application before the court. They were not. So it doesn't, you see, your case in court is not determined by the number of hours you stand on your feet talking. It's based on the content of your submissions. And I must recommend lawyer for first respondent. You were there. He spent 3 minutes. 3. Brevity has always been the soul of wit, not long submissions in court. No. We also submitted before the court. Lead Counsellor Kutrapa was on his feet for no more than 10 minutes. And that's the result you get. A plethora of legal cases quoted in court does not yield to a determination in your favor. It's about the law. It is about the law. And it's the law we are concerned with here. If I may quote Sir John of blessed memory, or say in Sunday, Kasatinti and Toponko. Kasatinti and Toponko. Brevity is the soul of wit. Any question?
Last question. Yes.
Asempa FM.
Because his argument was that he mentioned March.
Asempa FM.
The justices of the Supreme Court, the law lords, are the master of their own rules and practices in that court. You would agree with me that ever since we started coming to court, they have never fixed the court date on Friday. Today, they have access to come back as early as tomorrow. That is how the trial is going to be run. So let us see whether we'll meet the 42-day deadline or not. But I'm certain and I'm confident that we'll meet it.
Thank you.
But before, this is the end of the press. Before I conclude this press interview, I wish to say something. And it's this, you see, before a stable owner comes to the stark realization that his trusted, revered, or star jockey is not ready for the derby, the race will long be over. Thank you. Okay,
anytime I feel lonely, feeling sad, only one station makes me happy. When I wake up in the morning, only this station makes my day. Yeah. Oh, Asempa, Asempa, Asempa FM. Asempa, Wasempa, Asempa FM. Oh, Asempa, Asempa, Asempa FM. Asempa, Wasempa, Asempa FM. 94.7
Asempa FM Suni Ekosiisen dwumadie no wasugu so a otie no 40 minutes after 2 6:30 p.m. na dwumadie eba ewie ene yawada, and we just went to the Supreme Court and yasan aba into lawyer Frank Davis, one of the lawyers for the second respondent, and mote se on nsem trofo edin komo the president of the Supreme Court enti yakwakofa ede abrewa nsem bebre na he thinks DNA was say ekwa na a judge for mpanyifo ede eto ya no, because say onutie lawyer Chachuchi Kata essay mre say oka de ye ono ade na enye de beto court no asum and de enye ne wan say court na ebon nsem no etu egu, and he makes the point say wo share first application a court netna so ewie 9-0 against the petitioner, and a second application is 9-0 against the petitioner, and you know free say ye ball bomu a anka omo ma 18 goals ama petitioner no anshebi enti eno ne nsemo a ewo Joseph Akable ewo High Court. Joseph akwaba na pom to saying yeah, me amit me ho. Enti just gone by was the press conference second respondent lawyer for before omono na petitioner na lawyer for aye won there ansa na ebebe no so no ene nsembe na akoso court ene
enseme de bebe the edi kai esha no obekaya not Tuesday na eba PM there were two main issues that are outstanding the edi kai a motion for stay of proceedings no, and a second any abridgment of time and I can say and Kebeya and court no a year review application on Tuesday instead of Thursday and Geneva court no took the view that those two motions are moot to the lawyers were asked to take some action, and then they proceeded to withdraw those two motions now since I am a court no able to be it we and no if fine money and no next year and after court no started or bed delay with the review itself and the issues related to the review. Now the first issue I delay with regards to the review no was a request by Mr. Chikata to be allowed to file additional documents in support of a year review now.
Ekosiisen on Asempa FM.
To some questions. And to that particular request, no court no able to be by unanimous decision. And only chain of course with legal arguments related to interrogatories and also court no about the conclusion that it does not met the threshold to merit its duty. And then also court no able to be. And in terms of the sum, you know, those are the issues I transfer.
Okay, and at every instance, no court ne makwaima a lawyer for the nyina one nine so the one argument etudwa. You would realize petitioner and lawyer no lead counselor Chachuchi Kata ekasai bebre na isi lawyer na the lawyer briefly no mono akasawi. Why was that? What do you mean? Na me busa se na ohwe argument na lawyer for no na lawyer Chachuchi Kata what do you mean Akable? Great. Na lawyer Chachuchi Kata ekasa eche na later is lawyer abem na the lawyer and so abem no mo na kasa briefly. Why was that? Is it say they thought say no mo ni bibia and they just wanted to be brief, and now say time ya dem mo na isa, which is which?
In fact, then Oman located time a more discretion. Nembra Otis a Frank Davis any action come across another point I know making it say Omomo hold the view say a yellow any embra in one sem day and yet Casatin and a dijuma a year Nyansa a war Casanimu and all the dijuma intentional or did he say Rakutampa Becca or Bonito because a semi unhiano and Osis when yes a Casatin bin or Kawe and Sema. Frank Davis said it too. In response to your question, and they say, "I court no allocate any time for a year addresses no a year or more discretion more allow it. Okasana Queen Monoma Kaseja wind up in the instance of Mr. Sikata. And so more or more exercise the distance among Kasade.
Okay, you so say and a judge for the betnas and instead of 7 ye nim no omo ye 9 2 na be ka ho na ye hwan mo
2 na be ka ho no the kind Justice Amadu Tanku and so Justice Professor Henrietta Mensah Bonsu only 2 judges some be ka ho be make 9-9 okay na initial decision is 7-0 review decision so the copy mu 9-0
Ekosiisen
on
Asempa FM.
Say Frank Davis akekabo ma osisi ade ekwakoye 18-0.
Oh, okay. What it means is that there was no dissenting view from the bench. Omunyina 9-0 straight for all the 2 applications. Wow. And finally, no court said that being a case nankasa shasi, and even before that, no, near him said one application will on to admit fact into EC and present some document being Sanyomano and no court neka hwasem.
There be court no anko hwasem. Emba na Mr. Certificate nankasa kasano.
Yeah.
Or making reference to the fact that in terms of admission of fact, you know, if the EC is served now within 14 days. A man respond there on an understanding of the rules, no, it will be taken that those facts have been admitted to. If you ask the stance, no, they are taking steps to find out whether the electoral commission has been served and when exactly they were served and whether or not 14 days, no, as one as answering.
Oh, okay. No, it was not an application to seek leave of the court to get the EC to provide such document, no.
It was written directly to the commission, and the court was also served in terms of the process.
Okay.
The court will be asked to intervene if any steps are taken that or many in Juma.
Okay. Yo, it is here no. The way has been paved for hearing Nankasa on the substantive issue no to begin. Shall say that being.
10 a.m. to the court, no, as I say, relating to the petition and the expectation is Mr. Johnson is saying that here, and Dr. Kwesa White and Brahma Hopaya, Umbera, Ada Karimna, Oma testified.
Wow. Joseph, my nasi, unless say be before be or how per se, what it tuja, Emma yet here. Great. And John Mahama Makot on.
There be Mr. Teddy Ketia and a Begin man. Peter McMahon, a Begin, Emma, and another Danka, Akufado.
You, my nasi Joseph, Bibiani Besanso about Hobio. Why? Great. Joseph Akable and Moten and Canadian court correspondent, didn't he? The way is now cleared for the substantive matter Nankasa into the frontier. John Dramani Mahama, Eko Court, no. Nyame yadomo ochena ena yetena se etumi akasa ansem no and enano no ye de tudwa emamote se eba se court no etena se fi ochena na issue said that court ni me was court no determine no Supreme Court ekeka ni nyina bomo ma be issues baako be enumbi ena eda court n'animu a was say omoshe na omutimi eka ho asem and ni nyina ye enkomo a efri nyame yadom ochena eko no enti se wuyi wasometie ne ye a court no ekan on the 20th of January 2021 time and almost set down issues ama mode of trial no court ne set down 5 issues into a free ochena eko cross examination ebeba so legal argument a lawyers ne be ni bibia no it should lead to answering these 5 questions no any whether or not the petition discloses any reasonable course of action and obeka way any the issue are easy and nanado raise say asemwa John Mahama Diaba court krano just say the requirement of article 64(1) say ye to abawie na wani nye ho a ubetime di akoko to challenge the validity of the election no omo free say asem na da court na nkasa na enhye da en question the validity of the election the be crank court no emane nhwemu kura won bontungu Supreme Court ka say omo decision on sa asem no omo de beba so omo de omo final ruling e ba no omo de nyina aka ho ayeden e de aba into hwe issues omo settle down and only number 1 in the whether or not the petition discloses any reasonable course of action. Number 2 asem a court ne be hwe aka ho asem whether or not based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63(3) of the 1992 Constitution. To way any issue number 2, our court no ebehwe aka ho asem. Entini nyina no de can say omo hwe
on Asempa FM.
Enkrata ne bibi egu on anim. Electoral Commission declare say Nanado na oye president elect no. Emre mu no mu busa say no question Nanado etumi nya more than 50% of valid vote cast. Said ye ohwe Ghana mrapon article 63(3) ka say obi e be declare president elect bia no e was say wonya 50 more than 50% of the valid vote cast. Inti issue number 2 ni some person omo hwehwem say yampa say Nanado enya more than 50% of the valid vote cast ana. Number 3 ni so ne say whether or not the second respondent still met the article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman South constituency presidential election result. And Timoba Kainswa, Eda na Jenmensa a declaration on the 9th of December. O Kainse Omoshe Aba Omonsa Kan. At the time, the yenya results from 274 constituencies. Na bako MI, bako na Techiman South. By Electoral Commission Chairperson Eka say o the Techiman South vote ni nyina Edema John Dramani Mahama Mpoa enya de ebesesa bibia. In the Electoral Supreme Court say omu issue number 3 and it's ombehwehwem ehu say no kre say at the time no say na ye the Techiman South de na eka ho say ye free mu still Nanado enya more than 50% no ana for which reason a East Gina so a declare no president elect and on a third issue a court in the Beshim. Number 4 whether or not the declaration by the first respondent dated the 9th of December 2020, the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63(3) of the 1992 Constitution. And Osha former President John Mahama petition on the court now. One of the reliefs are now all pay se court na emfa emano and say Jean Adukwe means Electoral Commission Chairperson. Declaration ankasa oye on the 9th of December no. Any Ghana mra upon Article 63(3) ebo ebra. Because according to Omono, Obia enya more than 50% wasanka Jean Mensa e declare no president elect. In the Supreme Court said ombeshem ehu sa declaration as Jean Mensa here on the 9th no and article 63(3) ebo ebra ana. And no ye issue number 4. And issue number 5 whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election result of 2020. In Timoba Kainswa, John Dramani Mahama petition or the shemu say Sawosha isi no nyoma bi the vote to be Nanado de ho na eni kwan say wo so de ma Nanado but mo keka sa vote nyina abomu a a little over 5,000 votes and a EC edema na ado. John Dramani Mahama free say Sadian an sheda amwa. In the Supreme Court say ombesen ahwehwem ebusa say sa vote pardon na John Mahama kan ho asem no. Eyadia enya effect bi wa result electoral commission chairperson editu dwane so ana enti no ene issue number 5 in the ochena petition hearing nankasa air ase no obeka Joseph Akable ka say likely say bibia totomu a witnesses are John Drawani Mahama Afa Esiedu Nketia General Secretary of the NDC and a Dr. Kwesa White likely say bibia to mochna on beba bigina witness box nim na counsel for the electoral commission and of a counsel for Nana Danko Akufo-Addo aye cross examination enti ochna bibia sha ase no ekosi time a hearing nankasa na se trial nankasa bebe awieye no sa issues enum we ene gu apono so a yehwe na yedi ho enkomo enti ochena yebehwe se de nioma ebesi akoye boy homoden se yebekwa ahoma no so enche na afei yedi enkomo enti uwo question bi anso a obetimi e de abrɛ wo adwenkyerɛ fa nsɛm ho a 0546 382 287 0546 382 287 yen WhatsApp line eno bomodin say odebeba ama yakan na wiase nyina nso etimi ehu sa de nioma esi eko enen so no say ebia wa anya kwan anhwe de ekɔ so Supreme Court ewo TV so a oba yen Facebook page Asempa 94.7 FM yen page on Facebook ubetimi enya videos nibi of how things went in the Supreme Court na wetimi ehu said nioma esi eko ntimunsha nso emfa emayen sanso na oba Facebook ubetimi de comment ego ho eno nso yebekan ede amount Supreme Mrs Supreme Court YouTube nso sa eno nso no ye channel on YouTube no Asempa 94.7 FM fa o comment ne ego ho nso emayen and would read all of them for you. Intimunction and so am I kind messages kakra na fe yenhwene yentimi ento aso Ekosiisen so ni high Asempa 94.7 FM. And to some of your messages we say good afternoon Obi. The petition by the former president is not attacking the validity of the presidential results, rather the mistake corrected by the Electoral Commission on the day of the declaration. That does not have any negative effect on the result. Waste of time indeed. Greetings to Honorable Henry Korte and Kwewu House NPP Patriot. Opare Samuel Ewo Alajo. And on the way are praying. Good afternoon, Obi. Can't former President Mahama advise himself that a case he is pursuing is a dead case and accept the reality and move on? The NDC should stop wasting our time. Anyway, please let us observe the COVID-19 safety protocols and stay safe. Special greetings to Alhaji Ken of Kentucky, USA, Dr. Geoffrey Brinkran of the Kolebu Teaching Hospital and Chairman Frank Akwesi Debra, MCE for Ablekuma Central. Nana Ekwiyamwa Boateng ewo Ablekuma Central. Abdul Karim, the political speaker, or Wenchi Zango, and more Wenchi no, Yadamunyana Sasima Munyana Akwaba, Wenchi for 8 years, ewo Iriase FM, Nafi Royal FM. And Abdul Karim said, you can clearly see the Supreme Court is determined to administer justice. The lawyers of the petitioner, Mr. Mahama, should follow suit and cooperate so we can finish this court issue and focus on building this nation. President Anado is in a hurry. Lawyer Godwin Eduji Tamaklo. Councillor Kwabana, apom te saying.
Obi. Ogwa Diadoroma. Mehoye. Na onso
Nyame adom mehoye papa and me hwe proceedings no on TV me hu sana ote lawyer Chachuche Kata echi pair and you were nodding to the argument and all of that. Me just say mentorship no koyi.
No. And then no being combona me say it's so strange say and found that no. Incidentally, May coup d'etat, they aborted one. So we saw a representative Jerry Rollins.
Yes.
Exactly.
Yes.
In America, say nyame adom no pa na wabɛyɛ nkyira kɛseɛ ɛde ama NDC amanyokuo no nyinaa because sɛ 1979 I started a different persons associated
Ekosiisen on
with
Asempa FM.
2021, which now 9 book and still defending. It can only be amazing grace.
Yeah.
Obi.
Yeah.
Nyame shira binam. Sometimes binam won tias here. Omuntu min tias here say adent na nyame shira we sa. Nwe shira men so sa. Nti bi ona adane etan hu. But Yankopon they decided who he decides to bless. Ebi obi baby amena menya me to studio ho ana me na me ye kwaku. But it's Obi's time.
Yeah.
And it will be Obi's time and nobody's time. If we all recognize these basic things about life, things will become easier. Hatred will go, envy will go, jealousy will go. For the person of Mr. Chikata, as a young man, I only pay the young man and something. So we benefit from the guidance. A very humble, extremely humble person. You can't suggest something to Mr. Chikata no one has to. Oh, now would have been I'll buy.
Ekosiisen on
Asempa FM. Look at the opportunity and Yankopon Amano as a teacher. Many years to come. When we say student 9 and then 9-member panel
That confirmed?
Yes. All
okay.
the 9.
Including Henrietta Mensah Bonsu.
All the 9.
Wow.
I personally asked him. All the 9. And Omunina Odibuo at the mom. So, in the level of humility, Empire na meboma Yankopon say, "Obetimi adom me, adom."
Yeah, yeah. I mean, at his age and
exactly.
the level of attention to detail, the top of mind recall of events, of issues, of cases, and it's amazing. It's unbelievable. I mean,
you know, he has passed 70 years.
Yes.
Sometimes the third or second day I call court. So that I no more fixed the whole matter and also in a different court. And you have to go and inform him so the panel
Asempa FM.
Or no, I'm imagining me a young man. No, the America crowd will make him cry or paint him. I mean, it can only be the grace of God.
Yeah.
The person is regrettable because of the nature of our partisan politics. Sometimes they hate. So we are unable to celebrate such individuals. Even though we know the quality, the stuff they are made of. But that's the essence of our politics, the nature of the politics.
And just quick information from Abdul Malik Kwekubako say the lead counsel was Edumwa Bosman. Yeah, supported by Chachu Chikata.
But he was, so I mean, he's not denying the fact that Chikata was elected.
Oh, of course. Yeah.
The old Edumwa Bosman.
Edumwa Bosman.
But you could always say Mr. Chikata was seated directly where he was.
Okay, and for more Mutieno, that May 15th trial, a lawyer Judy Kahwa Semino, and lead counsel Edumu Bosman, supported by Chachu Chikata, Monica Evans Quason, and one other, and na Ejinemu Edema applicants. And Mobe Kain so say the last time one bodyguard of former President Rawlings, Edin Komono, or mention this particular case and the fact say lawyer Chachu Chikata and Ejinemu yi omunina free condemned cells ewo in Sawem.
And like Mr. Bakon Kaya, the main point I'm personally making is that if this man has been part of this whole NDC thing from 79, Today is 2021, and it's equally relevant to the affairs of the NDC. I mean, how many people will have this opportunity? And so, as a young man associated with the NDC, I cannot help but to thank the Almighty God for his life. And then we can be big friends. One of the things I usually celebrate is the 18th of June. No, because so. What about 18th June? I'm so. The day you were incarcerated. No, say, no, say. It can only be the grace of God.
Yeah.
Sometimes people may mean the thing for evil, but God has his own plan for everybody.
Yeah. Lawyer, yes, I mean, of course. Yes, Chachu, celebrated lawyer, very, very, very solid, astute lawyer, no doubt about that. But the argument in court on two major applications, 9-0 against him, that can only mean maybe the arguments were not solid after all. And
in fact, Mekai said in the Dana Bodakwi trial, the criminal trial, he brought an application for stay. Eventually, no, court nena yajin. I can cross the revised Court of Appeal rule 27A. Only who can cross to bring the stay at the court below. When we say fast forward to 2019, the Supreme Court departed from that decision. When we say,
oh, okay.
Yes.
Okay.
And then the Magna Carta decision now, Chikata.
Now all referred to no. Okay.
Yes. So, I don't give consideration to it. Time and circumstances can determine how a court will proceed. Subsequent events, subsequent group of persons may look at it and say, no. Why? Interrogatories in 2013. So it was a 9-member panel that granted.
Mm-hmm.
And
yes.
So a 7-member panel, I think otherwise, based on different set of facts.
Yes, and different circumstances.
Absolutely.
Mm-hmm.
So, sign your money there. For us as lawyers,
is it the case from Baby Awujinano na onye surprised say ruling the course and now say we free say the argument I'm put for and I said the grounds from review no and na a shaky kakra, or you think you did your best?
Let me simply ask you.
Mm-hmm.
I mean with all due respect.
Okay.
On the 19th, the court based their decision on relevance. One. Okay.
Yes.
Good. The questions of relevance, sometimes during when the actual trial is going on, and that's when evidence will be proffered. When we say, even at the basic trial, at that time, you better consider issues of relevancy and admissibility. Now, we said the court would have set the issues down for trial.
Yes.
Because at that time, application for direction would have been taken.
Mm-hmm.
So the court knows the issue that has been called to answer. Sebio, we filed this application for leave to administer the interrogatories on the 12th day of January. And
that's correct.
19th in our court in the ruling. The Ben our court started the issues down for trial.
20th.
By which time they had already declared that the questions were not relevant. And based on what issues? When we say Mr. Koto Ampao fell into the trap by now telling the court, say,
Asempa FM.
But the issues you have said are 5. These questions, how relevant are they to resolving the 5 issues? As at the 19th, when the court gave its ruling, were those issues set?
No.
2, what he said, with respect, Professor Henrietta Justice, maybe sir, Mr. Tikata. So, but why can't you ask this question under cross-examination?
Metepa.
Obi Sebio, questions you have declared as irrelevant. How can you ask them under cross-examination? Because immediately you ask, the lawyer on the other side has been armed to object to the questions as being irrelevant. And admissibility, a determination is made on relevancy. So having declared the 12 questions as irrelevant on the 19th, if you're a lawyer and you proceed under cross-examination to elicit questions based on those
answers based on those questions.
Based on those questions. The lawyer on the other side will immediately say, my lord, I have an objection to the question. Obebisa grounds, relevancy. And his only basis is that, oh my lord, on the 19th, these questions came and you declared them as irrelevant. Having so made that declaration, an irrelevant question is inadmissible. You can't admit it.
But lawyer, is it not also on, because it's here, it's on record, say your lordships and Kasa Aka said the question can be put forth during cross-examination. And
so the ruling of a court is what is it? And your question is on Mubitae. The ruling of the court is that the 12 questions are irrelevant.
And the point of relevance, and you're linked to the timing. Irrelevant this time, but it can be relevant during cross-examination.
And I make a thought. You see, in the name of expedition, person entitled me for contempt. And then they say, Sebi, trial. Sebi, some of the lawyers for the second respondent. And in fact, let me see here, trial. The issues are always set at the application for direction stage. Into at the stage of hearing Nankasana, the court has already at the application for direction stage. When the question is needed, it is a bizarre question. The lawyer will say, my lord, look at the pleadings filed, look at the issue set, and look at the question. It has no nexus to the question this court is called upon to answer. And for that matter, it's irrelevant.
But lawyer,
today says by court, objection sustained, objection overruled. Me say, as we speak, your reason for dismissing the application for leave to administer the interrogatory, among other things, it's on the question of relevance.
Yeah, but and no, in the specific words of the court, and with your leave, I'll read it for a TF for what you say. The court is of the opinion the crucial issue of relevancy has not been established in this application, so this instant application, the question of relevancy has not been established. That relevance can be established during cross-examination.
No. Let us not read the ruling in isolation. It's a ruling made relative to an application to administer questions to narrow down their issues. Then you said those questions, the 12, they are not relevant. The only basis on which you can make a determination of relevance under the Evidence Act, Section 51, is that it does not help the court in resolving the issue at stake. What is the issue at stake? There are 5 issues.
Yeah.
Yes. And I mean, as at the time, on the 19th, were those issues set?
No.
Anything that Mr. Chikata can say, unless, of course, the lawyer for the second defendant knew ahead what the issues were going to be, then you cannot be making that suggestion. Because, Onunkwa, you remember, say, Mr. Akotampa, issue 1, issue 2, issue 3, issue 5. You know, this question. How is this question going to help the court to resolve these 5 issues? You heard him. As at the time the court made the determination of the interrogatories and gave its ruling on the 19th, were those issues set?
No.
So what did the court use in making the determination on relevancy?
Because Colin so said at the time, so that would say argument from the respondent. The counsel for first respondent, for example, said the answers or responses to the 12 questions, have already been given in their response to the petition.
No,
and I think counsel for second respondents also can the same thing.
First. Interrogatories.
Yes.
How are they administered? You administer it on a person who had responded.
Yes.
That is why in 2013, upon the EC filing their answer to the petition, filed on 27th and amended severally, it was on that basis that lawyers for then petitioner, Mr. Akufo-Addo, filed the application for leave to administer the interrogatory. What has changed today? I've heard the suggestion that, now we have CI 99. Now you ask them, where in CI 99 is it stated that interrogatories are prescribed? Also, no. What the court said is that the court will not apply it. It didn't say it cannot be used. Please, when you say you are bound to comply strictly with CI 99, and for that matter, you will not apply Order 22 of CI 47, what are you saying? I am bound to comply with some, and so I cannot do A, B, C. What it means is that what you are bound by does not allow you to. I mean, let's not engage in sophistry. Let's not engage in sophistry. I mean, it's a very, and you see, it keeps coming. Okay, on the 19th, when Mr. T moved the application,
Ekosiisen on Asempa FM.
Mr. Kotompa, in opposing, he said, but Mr. T, you can ask these questions under cross-examination. Then the court gave its ruling and said, irrelevant. And then other reasons. Today, by sheer whatever providence, her ladyship professor, Mensa, we always call her our mother, ask the same question. Now, there's a determination that the 12 questions are irrelevant. Effectively, my adversary is armed with that ruling. It's a ruling of the court. And like you said, 7090. So now when Mr. T decide to ask any of the 12, and the lawyers there say, my lord, in this your ruling, affirmed by your review, whatever, you said these 12 questions will not be allowed to be administered because they are not relevant. That is it.
The Supreme Court can depart from their own decision, no?
Please. Let's
and possible. Are you saying, say, a cast in stone? Say, if the circumstances change and relevancy is established, that Supreme Court ain't me overrule the objection from.
Let's mature say, and I'm person driving me into the realms of contempt.
No, any conjecture. Says you see, what can happen?
Conjecture. I say contempt.
Contempt. Okay.
Into the mami, Mr.
No, but a relevant question. So na me busa no ana me bo lawyer.
Me pass say irrelevant. Ebi ana mo na me ma no ebe put me into the realms of contempt.
Okay, I get you. I get you. But based on sa argument, no, then sitting here and make us say and you might as well withdraw this whole petition from court because Semun to me who free say you are now stopped from asking those questions during cross examination. Then more quiet then. Is that the Mun to me
Obi. Madam, who are law, you appreciate the intricacies of the law. A judge, the same judge, had given a rule
Asempa FM
that a set of 12 questions you had intended to administer on the same person. I remember saying in this case, the interrogatory were to be administered on the chairperson and the chairperson only. And your question I made to me, I if I could be Mr. Peter McMahon. That be McMahon, Abeka said, Electoral Commission said you why a mistake inadvertently. That be is in a kind. And that is why I was seeking to administer those questions. Now, Sesiano, Sebe, court is there. Those 12 questions, meet me administer on the chairperson because and yet relevant. Now, the same chairperson comes because we are filing a witness statement. And she's the only person who has filed a witness statement. Oba, what has changed? You see, Obi. Wow.
Okay. Lawyer, Mami Musa Sasemi, in reference to what has changed, you know. Say, Uye counselor, na se ebia ebase u raise these same questions during cross-examination. Na counsel for respondent no raise objection. Won't mean sorry in quote what, for example, Mensa Bonsu said today in court.
Is that a ruling? Is a ruling? Your colleague lawyer on the other side is holding a ruling in his hand. Certified copy. Signed by 9 justices of the Supreme Court or 7. Now, so during the hearing, my lady asked this question. Is that a basis to say an objection should not be sustained? It can never be. I was just eliciting a response, and the lawyer answered, I'm satisfied. Subsequent to this, I have given the ruling. And remember, I said the ruling came after those questions were asked. If the court was minded to make allowance, the court would say, in this ruling, these are questions that counsel can ask during cross-examination. But giving allowance in the ruling for you. It has now become part of the court ruling. There's no such thing. There's no such thing. So effectively, you have shut the door on those questions being asked. And what we say, when Mr. Chikata gave the response, who said, my lady, Prof.
Yeah.
One time be that question be abion. Because Mr. T said, if the questions are irrelevant today,
how can they be relevant
in 2 days' time?
Asempa FM.
The same witness that I was seeking to administer those interrogatories on.
Okay, indeed, I think the answer I seek, probably, ebe question and now person will be here, for fear of contempt, if the court, having recourse to a more decision on the 19th, cannot, in 2 days' time, depart from that earlier decision and says,
what will the court be saying is the basis for them? What we say, Constitution can say, Supreme Court can depart. But or say, some will depart there, or reason. Or means not on the spell of the moment, no one can do. Today, maybe where we slept, we had a vision or an encounter with Angel Gabriel. Into Yasasa that be. Or say it must be grounded, it should be reasoned.
Yeah.
On the country.
Relevancy. At this time, it is relevant. Then it was not.
On what issues?
On the issues set out, the 5 issues set out.
But and the issues, were they not there when the court says the threshold for review was not met? Obi. So the court, in giving this ruling, I will refer say 9-0.
Yeah.
Did the court not say that the threshold for review has not been met? Will it be met in 2 days' time?
Lawyer, inti way forward. Court so Chinamumra hearing begins tomorrow.
Yeah, crowd and then I ready crowded that. There are mosquito by witness statement.
Or the Nibia by.
Oh, into which I know what you court them in another kind. Like he was refreshing his mind on it. Because we were thinking, say, the review application will be taken so early.
Yeah.
And so the hearing is that, because remember, I said that was why the adjournment was for the hearing to commence. So we came, having prepared him, say, possibly today, they will seal his mouth. One will say Israel, as a lawyer, Mr. Chikata would ordinarily, but for the witness statement, he's supposed to lead him in giving his evidence in chief orally. But the evidence in chief, and also as your witness statement.
FM.
So the court will permit Mr. Asidun Ketia to have that witness statement to be adopted as the evidence in chief. So we're thinking, sir, and then Mr. Chikata will take him through that. Then there be the lawyer for ECB Bisano
Ekosiisen on Asempa FM.
Then you steal his mouth. Then tomorrow, when we have a full day, you can come and do the cross-examination. Who we are. Then my learned senior, Akotampao, will also come.
That's why you're not on the cross-examination. Okay.
Yeah, we are. Then there be Wesa White will come. Then the same thing. We are, then we are done with our case. Then the witness for the first respondent, Jane Adukwe Menster, provided I mentioned the name well. I'm also mounted. Then the lawyer will put the witness statement as the evidence in chief. Then Mr. Chikata will start the cross-examination.
Okay.
The lawyer for the second respondent may decide that, look, there's no point cross-examining her. Then, Mr. Peter McMahon will come into the, exactly. then the hearing is done.
Now, train. Now, if you train ruling
Your lordship's the court may give the opportunity for written
submissions. Okay.
Ekosiisen on the court to give a day for judgment. Which is year 99. I can say Osha's second schedule now, or say judgment should be in March.
In March, yes.
Yes. So depending on, and that is why some of us saw this whole argument of 42 days as a complete misreading of CR 99. Because CR 99 can say January, February,
March.
And also January to be for filing.
Yeah.
Then March for judgment. But you saw that our friends created the impression as though the 42 days starts running from the 30th of December.
Okay. But lawyer, the other thing, and we be in final point. Now I shared yes. Is our CI 99
the result, no.
Yeah.
There were correction of the correction, and then there was a correction of the correction. Now we can't find out. Now we grand finale.
Now we was say CI 99. No, Emma room for evidence in chief. No evidence in chief.
No. So another question. We are saying that we are doing this petition strictly in accordance with CI 99. Yes, sir.
Yeah.
Where in CI 99 does it allow for witness statements? We have to go back to the amendment to the High Court Civil Procedure Rule, which allows for witness statements to be filed. Where in CI 16, which is the original Supreme Court rule, as amended by 99, does it allow for witness statements? But overall, the Supreme Court under Article 129 has the power in exercising any of its jurisdiction to use any of the available rules of procedure, obviously excluding Order 22 or CI 47.
No, and the other thing, because more prepare about Nano. My point about what happened at China and say yes, as part of the discovery process, and person will take advantage in just the files are interrogatories, no, and no armano.
And sorry, when we say interrogatories, which are Nigerian authority now, the bar courts, Abubakar versus Yaradua.
Yaradua.
When we say in the 2013 way, it's the 2008 petition. So all these materials has always been available to our court, and that is why the court had no hesitation at all in 2013 in seeing it appropriate
to allow for the interrogatories. No,
absolutely.
Yeah.
And remember, sir, those questions were questions administered on Dr. Farijan. Then, the only thing that has changed is the name of the petitioner and the name of the witness of the first respondent. Yes, here you have a John Mahama, and then you have
and what has changed also is the question of relevancy. The question of relevancy.
Where 9. The previous one 9, and now we're 7. And I was relevant. So relevancy discussion. You have it extensively.
Yeah.
I mean, we say in your heart of hearts, when we say a point has been made, but there is not within you to say.
It did not make question and say
because you see, eventually once you become a lawyer, these things will play back to you. Okay? These things are going to play back to you. These things, they are going to play back to you. And it will be very obvious. Maybe looking back in some 5 years to come, because you know what, we could have decided otherwise. But that's entirely within their way.
Now my question, and it says, you see, the substantive petition, no, so interrogatories here, I go through Amamono. A damaging case, no, in any way.
Ekosiisen on Asempa FM.
Oh, a lawyer, I say lawyer near what Mr. question under cross examination. Then your colleague says, "So, my lord, I object to this, blah blah blah. No, I'm on the ground. So cancel. My lord, I'll withdraw and I'll rephrase the question." So just here. Into being a kind, I said there are many ways to kill a cat.
To kill a cat.
With all due respect to my national chairman, the late Governor Eji, Doctor.
And what it means, they say the 12 questions no can be reframed and asked during cross-examination.
I'm only saying is a lawyer would always find a way. Like they say, there are many ways to kill a cat. And I Obi.
No.
Say yeah, movement when you do one rule. Then I cover this I
Council, Mama Nase, o Leonard colleague, face out. That we are not the Miniano, and the Miniano. I don't know. A higher crime, Face out Ibrahim Sisse Eska, wa crowd say, Obi Ejudi is wrong. The 42 days is captured in CI 99 and the election adjudication manual. Please read page 42 as sent. And okay, page 42 now. Eka in the last sentence, not say, reading the above provisions conjunctively with the second schedule to the Supreme Court rules CI 16 as amended by CI 99, the court is obliged to comply with the strict timeline set out in the schedule so that on the 42nd day after the filing of the petition, a judgment would have been rendered in the matter. And we're from the Manual on Election Adjudication in Ghana, 4th edition. Too bad. There Ejudia Homano Ate Eko. But that's what lawyer Faisal Ibrahim Sisse at the Abba. And it's looking like the 42 days is captured in this manual. And the manual no references CI 99. And that's where we are. Ekosiisen in higher Asempa 94.7 FM. Load of your messages. Okay, I hear Ejude is back on the line. Council Inti, final point Faisal Debay, yes.
Yes, I think that misapprehension and Koforebre and among kind the entire rules, almost kind of in isolation, and it's not a good way of reading the rules. Stay at the tail end of the rules, the amendment, or say the hearing should be done in accordance with the timeline as provided in the second schedule. There are two schedules. A lot of people almost focus is on the first schedule. Much of
me too.
Second schedule, a honor almost shows there. January filing any honyoma. February the LCN, then March for judgment. But someone say, what do they mean in the rules, a second schedule, when they say judgment in March? What does it mean? If 42 days are, what counting 42 days from 30th, will you get judgment in March? Obi, the
Yeah.
petition was filed on the 30th.
On the 30th, yes.
Of December.
Yes.
42 days from.
30th, that should be somewhere in February.
Yes, sir.
Mm-hmm.
Good. So when the rule maker says judgment in March, what do they mean in the second schedule?
Oh, okay.
Because the maker of the rule in the second schedule was there. March for judgment. In fact, a table, January filing, this, then March judgment. What do they mean by that? Because obviously, if you are counting 42 days from 30th of December, it will never take you to March.
Asempa FM.
It will never take you to March. Or Minya Fraser, can say there's no second schedule.
No, there is.
Ekosiisen
And
on
so,
Asempa
how are
FM.
they interpreting the rule?
Council, my FNC, I appreciate your time. Medasepa.
That sense of Obi.
Great. Lawyer Godwin Ejude Tamaklo and Motene Nkanoye, spokesperson to the John Dramani Mahama legal team in the ongoing election petition case before the Supreme Court of Ghana. And Mamina Faisal Ibrahim Sise so Ase for coming through with his contribution. Messages ni bebre na wa we say listening to the tone of lawyer Tamaklo on radio, checking the mood of lawyer Marietta Brew, assessing the submission of lawyer Baba Jamal, it is obvious they know within their heart that the game is over for them. Okay, which other messages are here? Before a stable owner comes to the stock, realization that his trusted or revered star jockey is not ready for the derby, the race will long be over. Frank Davis, to who the cup fits, a word to a wise is enough. Prince Odeneho Opon. Obi, I must tell the NDC are just wasting everybody's time. From we have won to run off 5 witnesses to 2, I don't think the NDC really mean business when they lie to their teaming supporters of having won the election. Kabiesi is in second D. There are other ones here. The application for review unanimously dismissed for failing to meet the threshold for invoking the review jurisdiction of the Supreme Court. 9-0. Chachu only spoke 100% Oxford English. That's Mankind in Elembele. Mankind or Elembele. Okay. I agree with lawyer Frank Davis that lawyer Chachu Sikata is always trying to convince himself than to use the law to convince the judges. It is obvious that they are in court just to test the law and not that they have a good case. Okro Yeboa, Ewo Breman Benin, and on the way Abraying. Messages no endorse, but one of the spokespersons for the second respondent, Nana Danko Akofado, a lawyer Henry Nana Boachi, Bebrena friend Nana B. Nana Akwabana Pom to saying
Obi, Nyamiadaromo, and so Nyamediache. Yetim Komudi and Adumara.
Great. Utimiko PM or court ne?
Oh, Obi, Masadia, Asudia Damiso. It's in an answer Nyamiadaroma. 8:45 there.
Now where do court ho?
Exactly.
Me did say what court way there you saw and listened to the arguments from all the parties on councils and pay. At the end of the day, 2 major applications before the court, court made unanimous decisions against the petitioner. So what your petitioner and lawyers now, they feel say the court was not fair to them, and that moment instances are And under similar circumstances, court nema ruling be a NA as a court no dani free or no the ruling a wamada ho. Sitting down listening as a lawyer, Ufri say omo complaint na merit kakra wom.
Obi merit to a cra ebi anim.
Asempa FM.
Now no mode kotu court anim say interrogatories ya kind of focus here. Open some mudin say for be a pimpim electoral commission. Court no adwin mu no. Penifo enso ni nyina o enso ni nyina na adwin ko benku. Say we no enya ade a ebeboa omudi gina enema be mi no mi ensa so. Say ehu hia the relevancy omuka eno ho asem. Enna the matters in contention no. Say ade a ye twe ho daire ya ye twe ho ye ka ho asem nyina no. Who be pani here Emma matters in contention at a dear year to direct. And some almost I could say because of an ACI 99, you know, they will not court no discretionary and obi discretionary who pay ocean near manimu now shares and near my to send
FM.
Now what I say we and a bit of the court said, "Nano anayedi asemno 2013. Amarita blew a pure pon mami kroye na on fast CI 9 mai. Obey Attorney General 2016. And on one for our county and to go CI 99 man. Ni di wom Obapa Marita blew a pure pon. The thing wom. It's not the CI 99 or Abba. Ababeyembra. It's a court as I Jinasuka say CI 99 into any the issue of relevancy, any the issue of matters or contention and there questions about the Buano and they PM CI 99 into they will not apply a year CI 47 at this time around. It Obi and from Sobenu when I was with to Quapai. What to Quapai? And I say, and you also have a co-review. And also, no constitution in my country. The Supreme Court, now if you say, when you end your one, will be to me a co-review. To review ye and penny for me, no, and about the home. And there of any
Ekosiisen on Asempa FM.
And now, Professor Obapa Henry Tamensa Bunshi, and the account. And Omuna, so no buyer, no. On the share near Omunia, my dad. So we the same from so be any. Send ye Moyen and Anon, Yens Yaba, Yabitia Semino, and Yadian Saka Bia womb. And the views are share into the moment the buyer and then laws are Omukuti, Titu, and now what videos or Obimaka. Say review. The principles regarding review no, are very strict. Because what percent court no san adwen. Court na hwene mo bebre no medical de o madwen aba. But we no percent court as san adwen. Na o percent court san adwen a. I want say would dey asem a emote. It is o chenie e kan na say o kan ye kan o. From so na aba, from so na aba, from so na aba, from so na aba ye no. Is it grave? A cause a miscarriage of justice ana. Almost from so mremo utie okani chatuma also I from so mrem na I am penny phone swing omafom mrem
Ekosiisen
na ofom mrem na na asama miscarriage of justice amama pepepe yo etri esi ana ama pepepe yo ye twa ne mene ana it is ana say na adansidie bi wo ho adansidie no amba betodwa bra ni edi asem no na court nim na even applicant no so no nim eti afi na wahu to hu ye no e no this adansidie na eye compelling no e motu no o this adansidie no aba ene no ebe sex court na dwen court say enye ma mo dia betu ye nim nyina no emu biya ni hono ma ye didi adwuma ebe yi enti mpanimfo nkono yo ene enye se mpanimfo mienu kura be ka ho no omo nso no omadwe ko fa baabi dabi mpanimfo nkono nyina se dabi asem no ne da na da eno so mo so mo ti kwa pai na pepe ya nye adwuma obi be dwuma menti ase.
They make the point, Supreme Court justices. Yes. Okay.
They also make a point of precedence. So now is year 2013. You think it's in me. Supreme Court. They are not bound by their own previous decision. At any point in time, and to say lower court, the judgment is free.
Superior Court, Bebano, yeah.
And in Supreme Court, a Court of Appeal, High Court, and yes, when it is when the Supreme Court, Omoka, some there, but Tina Ometima is imagining. It's in Sabian that I just admit a lawyer from penny 4 power when him because no, you can't say. International, yes, I can say. Now, furniture to ya dear Grandpa, said Yado, said the continue Ukrainian Kaka. After graduates, I don't know the Nanado Danko Kufa to Busaya, the Mano. Nine idea, John Dramani Mohammed, court episode one. Creating a certain impression, be said, as a Obu Bibitia, a John Dramani Mohammed. Very unfair comment. Very unfair comment. But ye answer him say,
Ekosiisen on Asempa FM.
Sasem with Namwa. And then she had the same thing to be. And every time I say, oh, we did the ruling of the earlier application by Ansana review Ibana, and Yama means relevancy issues in contention, and the fact that it's here, and then you will see I-99 and Omojinaswa, Omodi Omanuasum about it.
Lawyers for the petitioner make the point, so what ye interaction occurs between Chachu and a bench now. One of the justices, Ebusa, say, na interrogatories omo pese still omo push no. Omuntimi emusa sa questions during cross-examination and they make the point, say we share ruling of the court on the 19th of January now. And only ruling they documented Ubia can refer to. In that ruling, no, court na ama any window of opportunity to even bring back those questions during cross-examination because NA say through cross-examination could raise any of these questions. Counsel for respondents never sorry I can say no. So a question way now your lordships mo ka say any relevant to the issues amama set it down say yemfanye ejuma. And effectively no court no abu won asan abra wonsu. They cannot ask those questions again.
Obi, I don't know, me coming to me said no because penifo ebusa say asanse me nanka obetimi ototo ayam kofu ya no a obetimi de apiem na obi say ne yabo ni abrawu so a obi and ya omo asema because sanya me siki ensem no esifan obi enya ya chiri and we are aware o kwa kope na ade ba kokwan po sai me ya ne se ana ha me se mo file se mo the witnesses in and baba enra mo the mienu and koye omo se interrogatories no and nka be mo sa de miensa no asa ka ho je etwetwema so am ntina se wo ba no na unyina so no wo hen na wa dance for no wo hen e di say na say justice of the Supreme Court no ba ku busa say sansem ya opese obusai because unim Ekosiisen on Asempa FM na obusa na say da ben na National Coalition Center no e ba ya it is adia betimi obusa Jane Mensa. And I think she'll be okay to answer them. But so Kubusa Jen Mensa say National Communications Authority for Boawa. And only a new matter be a person introducing. Because Jen Mensa so Kubusa say a year regional coalition center no ebaya. I will learn him to bet me a cat was a will see and I edit to them. Obusan say Quamba now far swa or transmitting results no ebaya because it may more challenging certain portions of the declarations no guarantee any some figures being no. And of course, the lawyer crack our court to say by facts.
Asempa FM.
By facts, and you know, questions more who busa they're relevant. Court allow. If it is completely irrelevant, court allow. Because the NCA but now one plead I will petition him say, oh, NCA for AD Electoral Commission. And don't you know your piano ye one come. Not say person go to use back door. Will you see a year cross examination? Now only introducing these new sets of facts there. And the court may allow. It is maybe one straightforward. In fact, some of the questions they asked, answers maybe be now crown our first respondent, the answer. And it being so even second respondent the answer. In fact, one Casacra petitioners no, petition the crown answers will be. Say Obusa Jane Mensa say time be no who say oye error na. Who say oye error na no correct no. I don't know say question we ade o say me say adaje o. Abra who say error between 9th 10th yenya ye who say omo the cat aba out the quarantine and a cat no public knowledge. And genuinely na ye mama chinchen court na say. For almost 1 week, we have been on this interrogatories. Almost 1 week. Because last week Tuesday, Obekaya.
Asempa
FM. And movie motion, no more Ekosiisen and a court ruling.
Asempa FM.
And a nay, a yawada. Now what you correct him? I say, Obiada say.
Nana.
And then your course, one.
Okay.
Mesate sena we are pure ponka say omo lawyer no make superior argument kasa tenteno case law o cite ya na nye relevant to the matter no ujina wona so don jere no maybe and easy lawyer. Kasa 3 minutes for CI 16.
Asempa FM.
Come far about review circumstances ultimately review about. Okay, we no cite mechanical law versus not the case no. Say I do mu na no. When in the NJ a ruling report, you can always critique, you can comment. But say Obama emotional and while you I say and somehow can you say you are being emotional about it and the what's up. Okay, we are not transiting. Senior Kutampa, a casa for not more than 10 minutes. As I didn't think to it took us a billion. Site cases we are. Mr. McCann relevant no. And on a superior argument. Debbie, and you know, justices of it's the penny for justices of the Supreme Court and so at Nasenso, Abuego, a Mumbienu, Asaba Beckham, Asabuego. When your superior argument, yeah.
Maya prepared for China.
We have always been prepared. We have always been prepared. Somebody can't say, "Ya lawyer for a Juma or Ebono." Look what your name. Lawyer Akutu Ampao, lawyer Frank Davis, lawyer Dapa Ado, lawyer Sheila Menka Premo, lawyer Kwesifi, lawyer ya Opong, lawyer
Ekosiisen on
Victoria
Asempa
Best,
FM.
lawyer Bright Ochre Ejikum, and a lawyer Dr. Ernest Owusu Dapa. A Juma almost young. We have always been prepared. And we are more than prepared, say Bishop Mochna. More than now, I'm a witness statements in Jack.
Yeah, I've read all of them. Yes.
What kind of person white today?
My kind person white, my kind of see don't get here.
Say person white, we will be agent or electoral commission. We see who say irregularities be a course. And you know, former President Mahama. It will call into the easy nine Jumaye. Now, any President Mahama Kokasa. Do Nam Kwanswa Okona say. Osen Kendi si for Bufuno.
The issues are sub judice.
No, the bill, someone what cannot. And I make us into way yard. And someone what thing I could see as witness. So, and one thing that is in Yana Jumaye. It way a idea would be about
Ekosiisen on Asempa FM.
Say, Yamma, Quina will call for my President Mahama. Then could you come a Ghana in your channel. O do the kind of a year easy cry, say, a young say, oh, Mudia go promo crantino, 24 hours crano, a possible soon be declared.
Asempa
Or would invitation crack or out. Later on, ensure a to baby. And then I hear some problems be Munya intino, or meant to be and declare. It not, they have always been the process to declare it. It was who sound from one. Our constituency now, any resource ban or Brandon, former President Mahama, and now could you come into no men's and channel. One class who I walk on, and artist said, Yabo Papa. Ah! Now, once they didn't get the answer, they say, Madame Jane Mensa, a possible say, or we are Mumma and Nado, Adaya, who are petting Takrem say, oh, really. Mama Rebecca Akufado. Obi. Almost say that.
Anna, yen train ya me much na. Me da se papa
Obi Yamin Shaw.
Me da se.
Ekosiisen on Asempa FM.
Lawyer Henry Nana Boache, Bebre friend Nana B, National Youth Organizer of the NPP, and you are one of the spokespersons for the second respondent in this ongoing election petition case. Bamunim says Ghana Nibia